welcome to When Pregnancy is Used to Deny Patients Their Civil and Human Rights. Today's webinar and the two professional continuing legal education credits we can provide are thanks to New York University School of Law, and in particular, Professors Sally Burns and Sarah Wheeler, as well as NAPW staff Dana Sussman, Sean Steiner, and Kendall Benson, who will be helping through the run of this webinar and beyond. I also want to thank our wonderful and prestigious co-hosts and sponsors. And these are Black Women's Blueprint, Physicians for Reproductive Health, the Birthrights Bar Association, Elephant Circle, If, When, How, National Women's Health Network, Ancient Song Doula Services, the National Perinatal Association, and the CUNY School of Law, Human Rights and Gender Justice Clinic. We will be eventually opening this program to questions, first by me, then by our co-hosts, several of our co-hosts, including Professor Cindy Suhu from CUNY, Cindy Pearson from National Women's Health Network, and Farah Diaz-Teo from If, When, How. I am Lynn Paltrow, the founder and executive director of National Advocates for Pregnant Women. NAPW is a reproductive justice organization where we use our legal, organizing, and education skills to challenge the ways in which pregnancy is used to deprive people of their civil and human rights. This means that our work is varied across multiple kinds of law and activism. For example, some of our work involves criminal defense on behalf of women who've been arrested or locked up because of pregnancy or an outcome of pregnancy, including miscarriage, stillbirth, abortion, or for giving birth to a child who is stigmatized. Our work includes parent defense, where the child welfare system is used to surveil and control particular families based on something that did or did not happen during pregnancy. And it includes the kind of case that brings us here today: pregnancy as an excuse to force medical interventions on patients, on medical patients, and to think about what we think of as fundamental rights. Early in my career, I was lead counsel in the appeal in the In Re AC case, Angela Carter. She was a woman who was forced to undergo cesarean surgery done in the name of protecting fetal life. It deprived Angela Carter of her right to life, and neither she nor her baby survived the forced surgery. Today, NAPW continues to work on behalf of pregnant people and pregnant patients, including Ms. Renat Dre. In 2011, she was pregnant with her third child. She had given birth to two previous children by cesarean surgery, both of which in retrospect seem not to have been necessary, and both of which were extremely difficult to recover from. For this third pregnancy, and in light of the future one she wanted to have, and you'll be hearing more about this case from our esteemed speaker, Indra Lucero, she carefully chose her doctors and North Wales Staten Island University Hospital based on their representations that they would support her in having a VBAC, a vaginal birth after previous cesareans. North Wales Staten Island University Hospital never disclosed to her that they had a formal written managing maternal refusals policy that authorized doctors to perform surgery on pregnant patients without their consent and without even going to court if they felt that would take too long. The doctors in the case, Ms. Dre is represented by Michael Bast, who I believe is in our audience today, is vigorously defending what they did. The forced surgery injured her bladder, caused trauma, and in their defense, they claim that pregnant patients simply do not have the same rights that many of us take for granted as existing for all of us. And thus far in the lower trial court in New York, the defendants, the doctors, and North Wales Staten Island University Hospital have had some success. One of the things the lower court, we are appealing, many of the groups that are co-sponsors today have filed amicus briefs. The court claimed that there was no discrimination on the basis of pregnancy in this case. There was no violation of state or city human rights laws. How is that possible? Because they do claim that everyone, including pregnant people, have certain fundamental rights to informed consent and bodily integrity. What they said was the policy's interference in a pregnant woman's refusal decision only applies under circumstances such that the distinction it makes are not solely based on a woman's pregnant condition. So the distinction, nice word for ignoring her rights, is not solely based on her pregnant condition, but rather take into account concern for the fetus. So it's my understanding, and one of our speakers is a doctor who can assure me that being pregnant means you're carrying fertilized eggs that will eventually develop into a fetus, which by definition is part of pregnancy. And the court in the circular argument says, but we don't have to grant rights out of concern for the fetus. We, meaning lawyers and bioethicists, take for granted certain foundational principles. For example, the right to the possession and control of one's own body as a core principle of liberty. And we often start our arguments in briefs and articles with this quotation: "No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law." This is a decision from 1891. And I think among the things we have to ask ourselves, and the speakers will be addressing, is for whom are these rights fundamental? Are there people who are excluded, have always been excluded from these protections based on their race or their status as a pregnant person, who may never have been intended to be included in these fundamental rights? Our extraordinary panelists will be addressing this and many related questions. And before I begin introducing our speakers, just some details for the next 2 hours. This event has been approved for 2 New York State CLE credits in the category of professional practice. For New York CLE attendance verification purposes, any course codes I announce during the program must be recorded on an affirmation form. Our organizer, Kendall Benson, will be dropping a link to that affirmation form in the chat shortly. So if you want CLE credits, click that link and be sure to write down any course codes I announce. I can't tell you how many of those announcements there will be in total, but I will make it clear when I say one. I also want to mention this is a 2-hour program, and despite what I just said, because we want to let the conversation flow, we're not planning on a formal break. But if whatever you hear leads you to need to step away, or you need another cup of coffee, step away and take care of yourself. You have the full biographies of these amazing speakers and panelists. In a minute, you'll be hearing from our first speaker. Each one will present for about 10 to 15 minutes, and then I will briefly introduce the next speaker. That will be followed by some questions from me, and then from some of our co-hosts, and then from all of you. And remember, you can be using the chat function and putting your questions into the Q&A. I am extremely honored to introduce our first speaker, Dr. Jamila Parent, who is currently, in addition to all of the many other things she has done, President and CEO of Physicians for Reproductive Health. Take it away.
Thank you again. So as was mentioned, my name is Dr. Jamila Parent, and I'm really honored to be able to present today on such an important topic. My role here as the first speaker, I think, is to kick it off with some context and a little bit of framing from the medical perspective. And I really want to own at the outset that my positionality as a Black cisgendered woman and an OBGYN absolutely influences the way that I think about and have thought about this issue. As Lynn mentioned, I wear lots of hats and work in lots of different spaces, including as a clinical provider and as the president and CEO of Physicians for Reproductive Health. PRH is a physician-led advocacy organization that mobilizes the medical community, educating and organizing providers using medicine and science to advance access to reproductive health care for all people. As practicing physicians, many of us came to this work holding a set of values grounded in our commitment to health and to healing. These values and principles include upholding the oath that we all took at the outset of our careers to do no harm. And while that may be our intent, the reality is that there are policies and practices that we may engage in, sometimes unknowingly, that do just that, harm. And so we must ask the question, how do we understand the ways that we, as healthcare providers, may be participating in and upholding systems and structures that disproportionately harm individuals and entire communities? Today, as we sit here having this conversation, it's not lost on me that it's following the most recent murders by law enforcement of Ma'Khia Bryant in Ohio, Andrew Brown Jr. in Elizabeth City, Dante Washington in Minneapolis, Adam Toledo in Ohio. And I think back to the days, the weeks, the months following the murders of George Floyd and Breonna Taylor, and the streets were full of protesters, rallying, demanding, insisting that we, Black people, be afforded the human right to live free from state violence. Many medical providers joined in as well. We saw providers out in our white coats, our masks, our scrubs, marching, kneeling, laying down. Organizations began issuing statements one by one. The American Medical Association, the American College of OBGYNs, the American College of Physicians all issue statements denouncing police brutality, condemning violence against protesters, and calling for inquiries into cases of police misconduct. We rallied, we demanded, we insisted, and then we went back to work. We went back to our clinics, into our hospitals, back to our offices and our ORs, and we crossed back into our spaces, steeped in power and in privilege and in complicity. Not seeing, not acknowledging, not understanding, or even attempting to grapple with the ways that we were upholding these same systems we were protesting against. The reality is that it's not simply the interactions between Black people and law enforcement outside the hospital that puts our patients at risk. It's also the criminalization of people in denial of human and civil rights within the health system when they interact with us, their providers. And this is especially true of my chosen field of practice, obstetrics and gynecology. The racist and exploitive roots upon which our practice was built, atrocities that did not begin or end with J. Marion Sims, have set the stage for the way that we think about reproductive health care today. In her book, Medical Apartheid, Harriet Washington writes about this now familiar painting. She writes about the innocuous depiction that's in stark reality to the truth, which was brutal and abusive. The practice of medicine was literally built on our backs and in our wombs. Experimentation, abuse, neglect of care in the name of research. White supremacy values and a hierarchy based on race was necessary to justify and uphold these practices. And medical science, we provided the scaffolding. There are deep connections between these inhumane, dehumanizing practices in the way we embody and understand our role as medical providers, practicing within this legacy, as well as the way it's connected to the denial of civil rights for pregnant and parenting people today. As we consider our commitment to care as medical providers, our desire to heal, to treat, and to help, we must also acknowledge that this work, our work, is shaped by the context in which we live and in which our patients live. Individual and community experiences with our health systems interact within a complex web that's overlaid in the social, political, and historical context in which we live and operate in this country. And we can't understand and address one without acknowledging, understanding, and addressing the other. And we have to start with the discussion about the part that we play. For me, that meant doing some really hard work in thinking about the harm that I have caused in my role as a provider of care for pregnant and parenting people, the ways that I too have been complicit. And that opened up a Pandora's box for me in terms of thinking about how to approach this work and how to organize other providers around this issue. But first, I had to name the harm, because the harm that we cause as doctors is often different than the way that we think about what it means to cause harm in medical spaces. And I'm just going to lift up 3 quick examples today, and they're by no means the only ways that the denial of civil rights show up in medical care, but the outcomes and the impact are the same. They increase the risk of criminalization of individuals and communities. They interrupt and remove agency and autonomy, and they allow us as healthcare providers to collaborate with the state, to act as agents and arms of the state through punishment and calling it care. When we talk about criminalization of pregnancy, specifically, we mean the punishing or penalizing of individuals for actions that are interpreted as harmful to their own pregnancies, including enforcement of laws that punish actions during pregnancy that would not otherwise be criminal or punishable. Criminalization also occurs when laws not specific to pregnancy are either applied in a discriminatory way against pregnant people or have a disproportionate effect on pregnant people. Criminalization of pregnant and postpartum people has taken many forms, including the passage of fetal assault laws, policies that punish or penalize pregnant people for substance use during pregnancy, as well as we heard earlier, the practice of judicial intervention or legal attempts at coercion for refusal of care during pregnancy. We see this criminalization of individuals essentially for living in poverty through the targeted criminalization of folks for their pregnancy outcomes. From prosecution for child abuse and endangerment for drug and alcohol use during pregnancy to murder and feticide charges for suspicion of self-managed abortion. In the cases of fetal assault laws, these statutes have been adopted across the United States as a way to limit behaviors during pregnancy that legislators deem and determine to be harmful to the fetus. Often these laws are passed under the guise of protecting pregnant people, but instead are being used to punish individuals for a wide range of actions. Criminalization of pregnant people for actions allegedly aimed at harming their fetuses pose serious health threats to people's health, to the healthcare system itself, and is a violation of their civil rights. And moreover, there's evidence of discrimination in the implementation of these criminalization laws, which tend to be disproportionately enforced against women with low incomes and people of color. This is especially true in the case of substance use during pregnancy. These practices of criminalization are disproportionately used to punish and penalize communities that have been historically marginalized. Despite clear evidence that exists showing criminalization and incarceration for substance use during pregnancy are ineffective as behavioral deterrents and harmful to the health of the pregnant person and their infant, and despite the fact that leading medical organizations agree that a positive drug test should not be construed as child abuse or neglect, pregnant and postpartum people and their neonates are continuing to be screened for the use of substances, often without explicit informed consent processes in place. This is a disruption to bodily autonomy of the pregnant person and their newborn, and is inconsistent with treating substance use disorder as a health condition with social and behavioral dimensions, and is a violation of civil rights. The truth is that most systems and structures often only support the right to parent for those we deem to be legitimate parent. And that's what substance use testing is done. Young people, LGBTQ folks, those with disabilities, people with low incomes are often left out of these narratives about legitimate parenting and not provided with those protections. Their parenting is judged, scrutinized, pathologized. Neglect and poverty are conflated, and the solution to poverty is often the separation of family. With the help of medical providers, those who are pregnant or have recently given birth are made subject to state surveillance and control, forced family separation, and child mistreatment investigations. The importance of respecting bodily autonomy is critical in the decision to refuse recommended medical or surgical intervention, such as a pregnant person refusing treatment for themselves or their fetus or refusal to undergo a C-section delivery. Pregnancy is not an exception to the principle that a decisionally capable person has the right to refuse treatment, even treatment needed to maintain their own life. The American College of OBGYN opposes the use of coerced medical or surgical interventions for pregnant people and believes that it is unethical for medical practitioners to use manipulation, coercion, threats of criminalization to compel pregnant people toward a particular medical decision or treatment, including those made during pregnancy and the postpartum period. Any statute or legal measure that utilizes the criminal legal system as a way to control or manage behaviors during pregnancy is counterproductive to the overarching goal of improving maternal and neonatal outcomes. Actively interrupting these practices means taking time to consider the true impact of our actions inside and outside these systems. So the question becomes for us as medical providers, what does resistance look like in these systems? What does non-collusion look like? What would and could it mean for us, those with often the most power in medical systems, to refuse to participate in criminalizing those we care for and claim to care about? Some organizations have heard the call, putting out statements against criminalization, but many of these statements fall short. Often there are no concrete asks or actions embedded in the statements. And so providers ask, what does it actually mean to refuse to collude, to oppose, and to interrupt criminalization? And it's simple. What this looks like is simply living in real time at the point of care, the values that brought us to this work, trusting, really trusting our patients to know what they need, when they need it, and how they need it. Understanding that all of our work and our actions must be grounded in agency, in autonomy, and upholding the civil rights of each and every person that we care for. Thank you so much for inviting me here. I look forward to the discussion, and thank you all for your time.
Thank you so much. And I know I've got some specific questions for you, which will come later, and some questions that I think you've posed to some of our other panelists. Our next speaker is Savannah Brown, who is the co-executive director at Black Women's Blueprint, and through Ancient Song Doula Services and the Doula Project, she is a birth worker and a reproductive justice advocate. Please take it away, Savannah.
Thank you so much, Lynn, and to the entire team at National Advocates for Pregnant Women. And Dr. Jamila Parent, I am just floored by the incredible groundwork you've laid for us to really go deeply in this conversation today. Much gratitude, and I can't wait to hear the questions that come out of our conversations. My name is Savannah Brown. I'm the co-executive director at Black Women's Blueprint, and really excited to talk to you today about some of the research that we've been able to do and the approaches that we've taken to this work as an organization. Black Women's Blueprint is an organization that uses civil and human rights approaches to organizing and to developing a culture where women of African descent across the African diaspora are fully empowered, and where gender and race and other disparities are fully erased. Black Women's Blueprint is also the convener of the first Black Women's Truth and Reconciliation Commission on sexual violence to occur in the United States. And we've been centering the needs of Black women and girls since 2008. Black Women's Blueprint consistently strengthens Black communities through programs and focusing on defending the rights of women and girls of African descent, and specifically looking at ensuring bodily safety and securing reproductive health and access. We strengthen our communities through centers and programs that focus on defending the rights of women and girls, and also creating and transferring knowledge, democratizing theory and pedagogy towards ending gender-based violence. Our work is also intergenerational, so across generations, across gender, across borders. We are also rooted in cultural traditions that affirm the dignity and rationale of all human life. Black Women's Blueprint operates a lifeline and brings doulas and midwives and birth workers, as well as health practitioners, to communities where women have little to no access, and that's around the world and here in the US as well, to maternal and often any form of healthcare. We work to save the lives of women and babies, on-site, hands-on interventions, including prenatal and postnatal crisis support. And we also offer support to institutional and hospital staff with how to work with diverse and cultural communities in times of crisis and even pandemics like the one that we're facing today. Our focus is sexual violence prevention, advocacy, reproductive and maternal health, TA, and training. And we also look at research and policy closely. Black Women's Blueprint coined the term the sexual abuse to maternal mortality pipeline in 2019 as a result of our 6-year initiative, a national sexual assault and gender-based violence intervention process, our Black Women's Truth and Reconciliation Commission, which was held in New York City, but it was a national strategy. And we were noticing the trends and the overlapping between the higher rates of Black maternal mortality and also the sexual assault crisis. And the pipeline itself looks at the heightened risks of pregnancy-related deaths that span over the reproductive life course as a result of violence, abuse, and trauma. So this report, which you can actually access on our website, outlines the concept of the sexual abuse to maternal mortality pipeline really as a concrete reality within the reproductive life course of not just Black women, but also Native women and women of color. The report truly exists as a tool to support strategies for shifting the culture around gynecological, maternal, and obstetric health in order to reduce the ways that rape culture and non-consensual behaviors towards women and girls, trans and non-binary bodies across the spectrum of interaction with reproductive healthcare systems. In dialogue about the challenges that survivors face, that young women face, that girls face across their reproductive lifespan, the personal quickly became political, and the sexual abuse to maternal mortality pipeline emerged, beginning with sexual abuse and unaddressed trauma, both compounded with weathering and the chronic threat superimposed by a continuous accumulation of stress from both racism and sexism and toxic stress and other oppressions. The combined unaddressed trauma and societal oppression that can lead to an avoidance of gynecological care or non-access or delay of gynecological, maternal, and often all forms of healthcare, all reinforced by the lack of trauma-informed care within healthcare services. And those were OBGYN, prenatal care settings, and retriggering symptoms that showed up as a result of previous trauma. We also saw along this pipeline and this continuum in our research, as we surveyed over 3,600 women, new incidents of abuse that further traumatized the survivor or individual, such as obstetric violence, all leading to adverse health outcomes that most severely led to maternal mortality and other forms of maternal morbidity. We also found that for Black, Brown, and Indigenous people, childbirth in the US, when we asked for the stories and we asked for the narratives, were not the most joyous experiences, right? That we see when we see baby showers go up and we see all of the excitement about a new baby coming. This was not the experience for Black, Brown, and Indigenous women, especially those who are already survivors of trauma. And as a doula and as a birth worker, which I know many of you who are listening and witnessing this conversation are also, I saw that firsthand in the labor and delivery room. Too often, these communities are denied equal access to respectful, high quality maternity care that is free from bias and discrimination. In maternity care units across the country, communities of color, Black, Brown, Indigenous women are treated with condescension, disregard, neglect often, and fear-based coercion. When asserting their rights to informed consent, bodily autonomy, and self-determination, they are subject to surveillance and policing under the same systems of structural racism that discriminate and control them and ultimately criminalize them. Mistreatment during childbirth can take place during healthcare through neglect, coercion, again, verbal abuse, forced interventions, and even forced surgeries when healthcare providers unlawfully disclose confidential health information to law enforcement or to state agencies that coordinate with law enforcement, and during incarceration as well. There's an intersection of violence that occurs for incarcerated women. And this all happens in the context of the US healthcare system, where extreme disparities persist for Black women, extreme disparities persist for Indigenous women, and in particular, where maternal mortality is rising, some interventions are overused while other effective options are underused. Obstetric violence, if you have not come across this term or heard of this term, is used to describe these forms of harm and coercion and abuse, particularly faced by pregnant and laboring people. And I will argue also across the reproductive life course, which I'll show you a spectrum in just a moment. Many of these experiences are often normalized by an anchoring in gender discrimination and sexism and dehumanization that we see happening in the medical system, as Dr. Jamila Parent talked about. It is in the fabric, the very DNA of the history of medicine, which is rooted in enslavement. And despite the current legal standards around addressing obstetric violence, there are measures that can be taken to intervene and prevent occurrences of violence. What follows is a preliminary list of just what these forms of violence can look like. And it can include a refusal to listen to patients, also dismissal of self-advocacy. So we hear a lot of people coming out of the labor and delivery room saying that they were not heard or listened to. Dismissal of patients' traditions around pregnancy and birth. So where there is cultural resonance, that not being honored in the space. Non-consensual procedures like inducing labor and unnecessary episiotomies, which is also routinized. Misinformation or lack of information around procedures. Disrespect and also verbal abusive language. And non-consensual touch and application use of force. There's other examples like for C-sections, sexualized language, and also sexual assault explicitly happening in the labor and delivery room. And we see where existing law fails to prevent this obstetric violence, right? We may have these rights, we may have these laws, but there's no meaningful recourse. So although we have values around these freedoms, the coercive treatment during childbirth still happens and the harm still occurs. And often the mirroring of abusive behaviors in action, tone, and gesture, the reproduction of negative power relations and dynamics, rigid instructions and schedules, shaming, judgment, all of that is a part of obstetric violence. And I think it's time for us to also broaden not just our definition of it, but also our responses to be both culturally attuned, gender responsive, and survivor-centered approaches where we see this pain, endangerment, and harm constantly occurring in these settings. And so when I speak about reproductive violations across a continuum or across a reproductive life course, in Black Women's Blueprint Sexual Abuse to Maternal Mortality Pipeline report, we really wanted to show where these patterns actually begin in early life, right? And so reproductive violations and violations of bodily autonomy and integrity, often for women of color, for Black, Indigenous people of color, happen early in their lives. And entering this pipeline and entering this concrete reality often reproduces it, re-traumatizes, or re-triggers many of these instances. And you'll see along this spectrum of reproductive violations that there are occurrences that occur inside of medical institutions. So for the purpose of this report, the continuum looks at women, girls, non-binary people's experiences in the following stages: prepubescent, adolescence, childbearing age, and that's with or without children, pregnancy, labor and delivery. And if you have access to a copy of the report, you can find this on page 47. It's much easier to read if you download the report and look closely at it. And really the purpose of this is to encourage the field to further examine the experiences of individuals beyond just the labor and delivery stage, right? Thinking about post-reproductive, menopause, postmenopausal stages, where in fact violence and the intersection of reproductive life course more often intersect, right, in the lives of women and girls. Our current efforts to address maternal mortality have paid little attention to these intersections of gender-based violence and gender discrimination, and yet there is evidence that there's a relationship between maternal and perinatal outcomes and violent experiences, especially those at the hands of a provider. And so all of the experiences on the continuum of sexual and reproductive violence increase adverse maternal health outcomes. And those include exposure to sexual violence and high adverse childhood experiences. So some are familiar with ACE scores, the lack of mental health treatment for healing services after sexual violence or after traumatic birth, and re-traumatization through the contact with a healthcare provider. And that's disrespect, obstetric violence, and non-consensual exams or procedures, which have become incredibly normalized. So the question is, where do we go from here, right? How do we implement? How do we go from pregnancy and prenatal rights to implementation? How do we go beyond maternal bills of rights, which we are incredibly proud of and are incredibly necessary? But there has to be an urgency around new approaches, and not just in theory, but also in praxis. How do we also de-silo the work, which is a major aspect of this report, so that lawyers are doing legal literacy with us, right? Who are doulas and birth workers and organizations and advocates, so that we understand it, so that doulas understand it and our communities understand it. At the grassroots level in New York City, Black women are foregrounding notions of informed consent, education, dignity, non-discrimination, quality of care, support, and decision-making as central to a broader conversation about body sovereignty, right? Sexual violence prevention and intervention advocates define body sovereignty as one's right to full control, autonomy, agency, integrity, and ownership of their own body. And if it's understood in writing, but not in praxis, or theory, but not in praxis, then how can we truly achieve and attain body sovereignty? What does that look like? And so it's also critical that there's a link between legal advocacy and organizing, that there's a link between the legal work and the grassroots. Unless it impacts the individuals whose stories we constantly hear, the teen mothers, the incarcerated pregnant people, then the legal structures will not effectively create obstetric justice. Doulas and organizers have to understand it and be informed, right, by the legal measures and interventions. And community members also have to be informed and understand it. And the implementation is not just coupled with the law, but it's also coupled with the training. I heard Dr. Jamila Parent talking about implicit bias and what it means to also transform from the inside medical systems and train practitioners to actually see the sovereignty and the humanity within those that they serve. And we know that in our deep roots of medicine, that there's a lot of unlearning and undoing that has to happen and that must be done. And so there's a unification of the fields that has to occur. It's not just with violence prevention advocates and reproductive health advocates, but it's also with legal advocates. How do we begin to do cross-sectoral work so that we are not continuing to see the data points where we see 32,000 pregnancies per year resulting in rape, where we see 70% of Black girls surveyed experiencing sexual violence before their 18th birthday. And on top of that, we receive data from doula agencies that tell us that 20% of the women that they serve are also survivors of violence. And yet there's not an interaction across the sectors to provide an integrative approach. And this lasting impact is only going to create more ramifications and more symptoms of trauma and re-traumatization in the lives of survivors and individuals that we serve and that we work with. And so it's really, truly, deeply about the advocacy. It's about the integration of our advocacy and our efforts, and about innovating our strategies above and beyond what we're currently doing, and going beyond bills, going beyond training, going beyond webinars, and finding a way that is dreaming up the alternative of what this care should really look like and the culture of health truly needs to look like. And so I'm grateful for this conversation. I do believe it's a start for us to find gender responsive care and interventions. And I look forward to the questions that will come and arise as a result of these presentations and move us rigorously towards impact. Thank you.
Thank you, Savannah Brown. That, you know, being here and all of you being here is part of, we can't de-silo if we don't build relationships. And so Thank you for your time and your presentation. Our next speaker is Mary Faith Marshall, who is the director of the Center for Health, Humanities, and Ethics, and director of the program in biomedical ethics in the University of Virginia School of Medicine. I met Mary Faith Marshall when I was litigating the Crystal Ferguson versus City of Charleston case. Professor Marshall was running the bioethics program at the Medical University of South Carolina, where I want to acknowledge that she risked everything about her career and her future by speaking honestly and testifying honestly about the hospital's outrageous policy of secretly searching their Black pregnant patients for evidence of drug use, and then in coordination with the police, turning that information over to the police and coordinating the patient's arrests straight out of their hospital beds. I'm sure she's going to talk some about that. And we ultimately had an important victory in that case. And yet, as you're hearing and will continue to hear, the work needs to continue. So please take it away, Professor Marshall.
Thank you. Thank you so much, Lynn. And what an honor to be here today with all of these fabulous scholars and practitioners and activists and all of the students who are here. So I am a bioethicist and do work in health policy. My area of scholarly work, a large area of it is coercive interventions in pregnancy and policy approaches to perinatal substance use disorders. And because I'm a bioethicist, I'm going to talk about some cases, maybe a couple of that are that you may not be so familiar with, and certainly a couple that you are familiar with. So this was actually a postcard that I bought when I was in England some years ago, and it's a parody of traditional British after dinner scenario in which the men stay at the dinner table to smoke cigars and the women go to the salon where they will later be joined by the men. And I use this really as a way to remind myself to say that, I think as we all know, the roots of, at least in the ethics world, the roots of what we do are based in feminist moral philosophy. And another reason for showing you this slide is to say that, and I'm not trying to be restricted to something that's gender binary here, but to say that the crux of the problem that we are all discussing today, I think is rooted in the notion that it is somehow all right to treat pregnant persons in a way that we would treat non-pregnant persons. I mean, that to me is the nut of it. I had the advantage of sitting on the American College of Obstetricians and Gynecologists ethics committee for many years. And I've told my colleagues on the call here that one of the things that I've said that I can now die happy because is first authorship on an ACOG committee opinion, refusal of medically recommended treatment during pregnancy. And the first piece of advice, the first tenet in that ACOG committee opinion, number 664, is that pregnancy is not an exception to the principle that a decisionally capable patient has the right to refuse treatment, even treatment needed to maintain life. Therefore, a decisionally capable pregnant woman's, that should be pregnant person's, decision to refuse recommended medical or surgical interventions should be respected. And the second tenet is that the use of coercion is not only ethically impermissible, but also medically inadvisable because of the realities of prognostic uncertainty and the limitations of medical knowledge. And there are a number of, what I think are, I hope are tenets in that document that can be used in the defense, right, of pregnant persons who may be threatened with coercive interventions, or to educate those of us in the healthcare field that such things are not okay, and that they certainly violate the norms of the professional organization for obstetricians and gynecologists. I just want to talk briefly about Ferguson versus the City of Charleston et al., which Lynn mentioned. This is where we met. I learned about this case three weeks after having moved to Charleston in 1993 to sort of start de novo the ethics program at the Medical University of South Carolina. And a couple of slides I want to show you, because they include what in theory comprised informed consent in those cases for, I believe, the 39 women, right, who were arrested with the collusion of the high-risk obstetrics case manager and the chair of the Department of OBGYN at MUSC. 39 women, only one of whom was not Black. And in the chart of that woman, in the medical chart, back in the old days when we hand wrote in medical charts, the high-risk OB case manager, Shirley Brown, wrote in the margins of that patient's chart, "Boyfriend is a Negro," in 1989 in the United States of America. And so this is just stark evidence, right, of the racism, right, that as others have already said, is inherent in not only the cultural bias, but the active racism that stares us in the face in these cases. So this case went to the Supreme Court of the United States, and thanks to Lynn and others, there was a victory there. I'm showing you this slide, and I don't expect you to be able to read it. This came out of the policy on substance abuse by pregnant women that was in the Medical University of South Carolina's policy manual, right, in the medical center, right? And I want to show you what ostensibly constituted informed consent, right, to have your urine screened and tested for illegal substances without your knowledge for people who met a certain profile in the obstetrics clinic. So as you can see, this is the boilerplate kind of authorization for release of medical information, assignment of assurance benefits, personal liability, and consent for medical treatment that I, as a patient at MUSC, signed, right, that any patient coming into a clinic would sign. There's one sentence here, or there's part of one of this 4-sentence paragraph that says, I further consent to the testing for infectious diseases such as, but not limited to, syphilis, AIDS, and I consent to the testing for drugs if deemed advisable by my physician. Right. So the argument in court in that case was that a signature on this document ostensibly gave informed consent by a patient to have her in the OB clinic to have her urine screened for illegal substances. The other argument that was rather creative that was used in that case was that because there were advertisements on public television in the Charleston area saying, come to MUSC and get with our program and you won't be arrested, that also somehow provided informed consent. This is also out of the policy, management of drug abuse during pregnancy. This is a letter that went to the women who were arrested from Charles Condon, who was the local solicitor then, who went on to become Attorney General of South Carolina, ran on the platform of criminalizing perinatal substance use disorder. And it's also in the policy. It was read to patients who had tested positive in their drug screening by Shirley Brown. And they were basically put on notice that they either continued with their OB visits and got into substance use treatment, or they would be arrested. And as we know, 39 were. This is also in the policy. So imagine that, those of you who are clinicians, or those of you, and all of us are, who would be a patient, that in the policy there is directive about questioning a suspect, right? In the case of all arrests, the suspect shall be questioned concerning the charges against her and a written record kept. And there's also questioning of the person about where they got the drugs, and signed by Shirley Brown. Okay. Just to show you, and I'm going to stop talking about Ferguson here, but what was really happening in this case? This is a paper that was written in a journal called Policy Review by Charles Condon, the solicitor whom I mentioned earlier, and one of the architects of the program. Clinton's cocaine babies. Why won't the administration let us save our children? And you could look this up online, or I'm happy to provide it. What was really happening in this case? And for me, the most morally reprehensive thing about the entire thing, right, aside from criminalizing perinatal substance abuse or disorder, taking newborn children away from their mothers, taking other children in those families away from their families, was that the program, which ostensibly was about healthy pregnancies and healthy outcomes of pregnancies and helping persons with substance use disorder become healthy, right? What this was about it was about making a fetus a person under the South Carolina child neglect and endangerment laws. South Carolina was the first state to do it. This was the catalyst for it. What that ultimately means is it was about abortion politics in the Deep South. That's what it was about. Okay, this shows a pregnant patient, right, after having been arrested, and her hands are handcuffed to her belt. She has shackles on her, around her ankles, and she has a towel over her head. Okay, I want to tell you about another case that happened in South Carolina, Jessica Marie Clyburn. You all may be familiar with the case of Bebe Shui, which happened in Indiana, a pregnant woman who attempted suicide and was arrested. Her fetus died. She was arrested and jailed, and that trial, she was jailed for a long time. This is another case of a young woman named Jessica Clyburn. This is a selfie that she posted online. So she's a young woman from North Carolina who in August of 2008 attempted suicide. And I'll show you the method. She was arrested for homicide by child abuse because her fetus died. She plea bargained in September of that year. She was in jail for the remainder of that time, plea bargained for involuntary manslaughter, and spent 8 months in jail and 18 months on probation. This is her history. She was hospitalized 13 times starting at age 10. She was in DSS custody but allowed to live at home, diagnosed with a personality disorder. She failed 3 grades. In 2005, contemplated cutting herself, jumping off a roof, walking into traffic. So suicidal ideation was something that she was familiar with. She was diagnosed with major depression, organic mental disorder, dysthymia, possible personality disorder. She attempted suicide in July of 2005 by an overdose of 2 medications, was living in a tent and homeless at that time. Her life changed for the better. She met a young man who became her fiance. They moved to this apartment building in Rock Hill, South Carolina. They were in a stable relationship. She was pregnant. They had an argument in their apartment one day, and her fiance left the apartment to go outside and smoke a cigarette and calm down. He heard her calling him. She had, afraid that he was going to leave her, basically jumped out of a 4th-story window in the Cobb house in this apartment building, landed on the canopy here, which is not a soft canopy, but actually has a hard canopy with concrete underneath of it, and suffered major, major injuries. And she was taken to the Carolinas Medical Center in Charlotte. She was admitted to an intensive care unit on mechanical ventilation. She had broken almost every bone in her body and spent months at that hospital and in rehab. And as soon as she was discharged, she was arrested and put in jail. I want to talk about a couple of other cases at Tallahassee Memorial Hospital. And the legend here that you see is your hospital for life. And unfortunately, it almost was for a couple of patients there. I want to make a point here, and I made it earlier when I read to you from the refusal of medically recommended treatment during pregnancy document. And that is that one of the reasons, right, that coercion is ethically impermissible, right, is that there is not only is it a harm against a person and a person's bodily integrity, right, but because of prognostic uncertainty and the limitations of medical knowledge. And one of the things that underlies so many of these coercive interventions is the fact that clinicians, that physicians, nurses, others feel so secure in their knowledge, right, that they feel morally justified in incursions against a person's bodily integrity and against their liberty. So this case at Tallahassee Memorial involved not only a case, it began with a case of therapeutic bed rest, which had been refused by a woman who was pregnant. She had 2 other children at home, and she could not, by her own judgment, afford to spend time in bed on bed rest in a hospital, and so she refused it. So here is documentation by in the Journal of Obstetrics and Gynecology that looking at a systematic review that don't support therapeutic bed rest for threatened abortion, hypertension, preeclampsia, preterm birth, multiple gestations, or impaired fetal growth, echoed in other comprehensive reviews. Annie Lyerly, who is a colleague of mine and is at the University of North Carolina, she is an obstetrician and a bioethicist, wrote an opinion piece saying that prescribing bed rest is inconsistent with the ethical principles of autonomy, beneficence, and justice. Hence, if bed rest is to be used, it should be used only within a formal clinical trial, right? And yet here's a patient being forced to undergo not only bed rest, but a cesarean section against her will at Tallahassee Memorial. So I'm going to read to you from the brief, the amicus brief in support of Samantha Burton. So in 2009, she was deprived of her physical liberty and her medical decision-making authority for the remainder of her pregnancy, mother of 2 who had declined hospitalization for bed rest. And so this is what happened. So the obstetrician went to the counsel for the medical center, who went to the circuit court and obtained an order for the patient to be indefinitely confined, which if her pregnancy had gone to term would have been for 15 weeks to Tallahassee Memorial, and to submit against her will. And this is frightening. This should send a chill up any person's spine. To any and all medical treatments, restrictions to bed rest, and other interventions, including cesarean section delivery, that, in the words of the court, the unborn child's attending physician deemed necessary to preserve the life and health of Samantha Burton's unborn child. Hearing was held by phone. Ms. Burton had to argue her case from her hospital bed. She was not assigned an attorney. She asked for a second medical opinion. That was declined, and she was not allowed to transfer hospitals. And the whole focus was on the best interest at that point of her fetus, although the language used was child, and on the legal premise that the ultimate controlling welfare of the fetus was sufficient to override her constitutional rights to liberty, privacy, and autonomy. So she was there for 3 days. on mandatory bed rest, was taken for an emergency cesarean section that she refused, and it was discovered that her fetus had already died in utero.
That is an incredibly horrifying and sad place to end. I'm going to have to.
Sorry, I'm sorry, I'm going over. The last thing I'll say is, ironically, Florida is the only state that actually has in its constitution an explicit right to individual privacy. So I'll stop there, Lynn. Thank you.
We'll come back to you. So
Okay.
thank you so much. It is now my moment. And I want to make sure I'm spotlighted to hold up one of our secret words for the people who are seeking CLE credits. And that word is labor. So once again, the secret important word you need to have, and there will be more in order to get your continuing legal education credits, is labor. Okay. Our next and last speaker is Indra Lucero, who, in addition to being the founder of Elephant Circle and the Birthrights Bar Association, has also served as an NAPW staff attorney and been directly and majorly involved in ensuring amicus participation on behalf of Renat Dre. So thank you very much, and take it away, Indra.
Thank you so much for having me today. I'm going to share my screen here. So starting off, I wanted to share this image, mainly to evoke the, I think, emotional or energetic feeling of what I would call the medical industrial complex. I think that word is a lot. And so I didn't just want to leave you with that word. I wanted to give you, a sense of a complex and why a complex, what is it about a complex that I'm hoping to evoke here with this image. And the thing about a complex, I think, that is important as we proceed is that it, from no vantage point, can you see the whole thing. And so it's impossible to really see the interconnections, see how one thing leads to another. You can't really easily make a, even mental map of a complex. And I think that's important with regard to the question of rights during birth, because these rights exist in the context of this complex. And often those rights are not even in communication with each other. And I think that is what leads to some of the outcomes that my colleagues have discussed. So by way of introduction, I'm Indra Lucero, a Colorado licensed attorney, founder of Elephant Circle, which is so named because we are inspired by how elephants give birth in the wild. The whole herd circles around, is in tune with the laboring elephant, provides support, but then also provides an incredible circle of protection and defense. And that's what we aim to do at Elephant Circle. Also the president and founder of the Birthrights Bar Association, a membership association for lawyers and advocates who care about the issues that we're talking about today. So as we proceed, I also invite you to just carry everything that you've heard from the previous panelists right here into this complex. It all fits here. That's part of what's interesting about it. You can think about the cases Dr. Mary Faith Marshall just told you about. You can think about that history that Dr. Jamila Parent told you about, and you can think about that report that Savannah Brown and Black Women's Blueprint created. This is the context. So first, what are human rights? When we're talking about this stuff, one of the ways we talk about it is human rights. And what I want you to know about human rights is that it's not complicated. That you don't have to know any statutes, you don't have to know anything about international law. All you need to know about human rights, it's a thing that everybody automatically has. And you get to be an expert in it because it's something that you can feel in your gut. So here are a couple examples of some human rights violations that to me immediately evoke that feeling in my gut. This is an image from Renat Dre's medical chart. And this highlighted portion says, the woman has decisional capacity. I have decided to override her refusal to have a C-section. Her physician, Dr. Gorlip, and hospital attorney, Mr. Freed, are in agreement. Ugh, that just hits me in the gut. Another recent and unfortunate example, the anniversary of Amber Isaac's death was just last week. And this is a screenshot of her tweet days before she died. Can't wait to write a tell-all about my experience during my last 2 trimesters dealing with incompetent doctors at Montefiore. And the link to this article here is in the bottom. This one too, reading this, knowing that she died just days after this hits me right there in that human rights place in my gut. To dive further into the human rights dimension of this, here are some things that I recommend. The White Ribbon Alliance has a respectful maternity care charter, and also was part of this incredible survey of women globally. They got 1.2 million responses, and the top demand was respectful and dignified care. So again, to that idea that human rights is something that we know. And finally, in 2019, there was a report to the United Nations that talks specifically about rights during labor and birth. And that, if you are interested in digging into international law and treaties, that would be a great report to read. Bringing it, though, into the US context, I first want to point out this important resource. You can read more, you can get citations to cases in the notes section of this. There's a lot of user-friendly graphics. But basically, I'll be talking about the same things that are in this, but hoping to break it down in some ways that I think share some observations I've made as somebody who's been exploring the complex. And let me just pause a moment to orient, who I am as an investigator of the complex. I am a queer, genderqueer, Latinx person who grew up in the Rocky Mountain West in the ancestral homelands of the Ute, Cheyenne, and Arapaho. And I was a person who gave birth. That is my orientation for this investigation into the complex. Once I was there poking around, I decided to go to law school so that I could try and figure out more about how this complex worked. But I didn't come in with the field of law informing my view. I think that's important. So to understand these set of rights, I think we have to break down what is the birthing person's rights, how do we understand the fetus's rights, and how do we understand the newborn's rights? So in the United States context, the birthing person's rights are unequivocally the right to informed consent, the right to refuse surgery or medical procedures, the right to receive treatment when in labor or experiencing a medical emergency. As my colleagues have said, ethical and regulatory standards also support these rights, and these rights are well established in the law. And there's really no equivocation. This is not one of those things where there's a lot of conflict or debate. There have been cases about this, and there's clear precedent. This is solid, which I hope at this point in this presentation gives you pause. How can we have such clear and solid rights and yet have the kinds of outcomes that we're seeing? That's good. Hold on to that question. I also want to point out that the birthing person's parental rights are not particularly well defined at birth. And I mean that in a very specific legal sense. Basically, it's because there isn't a lot of law establishing the parental decision-making of the birthing parent, while there is a lot of law establishing other things about parenting. One is quite simply that the birthing person may not eventually be the legal parent, because there is some wiggle room there, basically. I think that also speaks to why we get some of the outcomes we see. With regard to the fetus's rights, and I happily put that in quotes because it is highly contested, and it definitely varies state by state. Dr. Mary Faith Marshall talked about some context in the South Carolina in particular, and of course we hear a lot. This is these are politicized, so we get people staking claims. But basically, in the legal context, the state speaks for the fetus. There isn't, in none of these state contexts, is there some mechanism for the family to speak for the fetus. That's not what any of these state laws do. And another important context with regard to the fetus's rights that I think helps explain some of the outcomes we're seeing are that these legal concepts have been developed in the context of abortion and violent crime. These are key contexts. So of course, if you head out with an inquiry that is framed by abortion or violent crime, you're going to get, that's going to shape what you see and how you define the terms, how you define the situation. Then of course, there's the newborn. The newborn's rights, specifically as a newborn, are definitely less defined. The parents speak for the child. This is pretty well established, but there's a caveat: unless the state intervenes, and there's a process by which the state can intervene. Claims on behalf of injured newborns, which are not necessarily the ones speaking for themselves, but claims on their behalf, strongly influence the contours of medical malpractice related to birth. So again, if you're thinking about this complex that we're in, this is going to be, kind of a big intersection. And the other thing with regard to rights for newborns into children is that rights accrue with age. So newborns, by definition, have the least rights of any minor. But to the extent that there are some rights that have been determined that would apply to newborns, they're entitled to equal protection and due process. It's also clear that states cannot punish children for matters beyond their control or for matters that, their parents were involved in creating. So the question about what rights are relevant to pregnant people and laboring people really has to do with how these entities are described, defined, overlapped, envisioned. And I want to acknowledge that even this rendering should be scrutinized. I don't think it's necessarily a correct rendering. We shouldn't necessarily be able to envision the fetus so separate from the birthing person as in this rendering. Some may even depict it more separate. I think there's room to really think about why and how we are thinking about these circles in these ways. And of course, then, even when the fetus is no longer an actual part of the situation, how the fetus is understood defines what's happening with both the birthing person or formerly birthing person and the newborn, who continue to overlap in their rights. So with this knowledge that this is the existing framework in the complex, we can start to see and imagine what kinds of policies does this complex create, and why and how. So one of the most, I think personally, striking policies I've seen coming out of this complex is this policy that was discovered in Renat Dre's case. So this is Staten Island University Hospital's managing maternal refusals of treatment beneficial for the fetus policy. Renat Dre didn't know about this policy when she was laboring at Staten Island University Hospital, and certainly didn't know about this policy when she selected this as the place that she would go when she went into labor. But this is the policy that the hospital proudly referred to in their defense to justify the forced cesarean surgery by saying, oh, we didn't fail to meet our standard of care as providers or as a facility. We just obliged by this policy that required that we do this unconsented surgery. And in fact, the hospital has gone on to say, not only did this policy excuse their forced surgery, but they need policies like this. The direct quote here is that the lack of a policy like that at issue, this very policy, would deprive those viable unborn fetuses of their right to life. I don't recall talking about a right to life that fetuses have. And in fact, that's because it's not a thing. That is not a thing. Not in any of these states, not in the most extreme state is that a thing. There simply is not a legal right to life for a fetus. But you can start to see, I hope, how in this complex, that idea, it's possible for that idea to manifest and inform policy, create policy. So what are some policy solutions? I know Savannah Brown talked about this, and I agree. We need multi-pronged, creative, adaptive solutions. We also need more feedback loops. Again, because it's so hard to see how the many systems interact within this complex. There's a real lack of feedback. Lawsuits is one way to get feedback, and I do think it's an important way, but also legislation, regulation, transparency through all these things, learning more about what policies people and entities are using. I also would love to refer to folks, and I saw in the chat there are some Colorado folks here. We have some exciting legislation happening in Colorado right now. You can learn more about it at this link. That we call them the birth equity bills. And we also have a birth equity policy platform that we're hoping can inform folks in other states who would be interested in bringing legislation along these lines to address these issues. And then again, I'd love to refer folks to the birth rights resource. Here's a bit.ly. And finally, for those who really want to dig in, and I know we've provided these resources to registrants as well, the amicus briefs that we've submitted specifically in Renat Dre's case really well articulate the legal context for these issues. So I highly recommend those. And with that, I'll turn it back over to you, Lynn.
So much, Indra, for that amazing framework that you provide. I now get to ask a few questions, that some of which well, a couple I want to start by with Dr. Perritt. And, we've just heard about cases, including Renat Dre's case, where doctors ignored, violated decision-making by their patients. And you, as a doctor, called on doctors to act bravely and to not do harm. But I just wondered whether, given your work and training in both birth care and abortion care, whether you've personally ever come up against situations in either context in which you struggled with, felt perhaps that the patient was not making the right decision.
I think that's such a complicated question to answer, right? And of course I have. And embedded in that, so maybe it's not that complicated. The explanation for the of course is maybe the complicated part. One of the things that I just want to really lift up that Savannah said that resonated with me so much was about the unlearning around medical education and I'm sure legal education to some extent, and anyone who is embedded in these systems, right? I love Indra's picture of the complex, these complicated and complex systems. I just want to be really clear, like I have only in my whole life wanted to be a doctor. This is the thing that I came here to do, right? And I believe in that. I believe in health and healing and supporting people in achieving wellness in the way that fits for them. And I also want to say I came through the same system that everybody else did. The same doctors that were in this case, the doctors that we're talking about that cared for or did not care for people in the cases we're discussing. And so it takes a lot of work to unlearn the things that we're taught about being the one who knows the most in the room. That's what we're taught in medical education. You are the most qualified to make this decision. It requires a good deal of unlearning. And the way that I think about it is as remembering why we came to the work. I don't think that any of us came to the work with the desire to exert our power and control over individuals during their pregnancy, birthing, or abortion process. And that's by no means to excuse any behaviors, bad behaviors of the folks we discussed or mine in the past. And so what we have to do, though, as we're going through these processes, is to remember that piece of our own humanity that we came into these systems with and work actively to retain it as we're in it and when we come out. And then for those of us who have made it through, who have an opportunity and an obligation to transform those systems, recognizing the harms that it has caused us, that it causes individuals and communities, then we must work actively to undo those things. The idea that I know the right decision for anyone is ridiculous, right? I know the right decision for me. And so reminding myself of that every single time I'm challenged by someone's desire to do something different, whether it's a person I'm caring for or somebody in my family or somebody I see on the street who may not have a mask on, right? I know what's best for me, and that's on period. That's it. That's all I know.
Thank you. Here's another one for you, and this comes from NAPW's commitment to de-siloing, to recognizing the intersections between issues. So I was wondering if you could comment on any differences you see in how informed consent is conceptualized and carried out when it comes to pregnancies that are intended to go to term and pregnancies where people are seeking to end them through abortion.
I loved Mary Faith's presentation so much about the deep connections between control of pregnancy outcomes that end in birth and the direct links to attempts to restrict access to abortion. And sometimes those lines are blurred, or we allow them to be blurred. These fetal rights laws, fetal assault laws, fetal personhood amendments that we're seeing are directly linked to attempts to restrict access to abortion care and just reproductive autonomy more broadly, right? And I think that the more often that we can remind people of that, to articulate that as clearly as Mary Faith did, the better off we will be. These are not unique and separate issues, and treating them as such, treating abortion or pregnancy or birth as an exceptional thing allows it to continue to be siloed. The control of the fetus, the rights of the fetus is the thread that goes through all of it, right? The idea that this, and I'm not a legal person, I just know that the person I'm taking care of is in front of me, and has the decision, the right to make decisions about their own bodies no matter what. And that's the piece that we have to hold on to.
And I'm wondering if you can comment on, many states have laws that outline and demand specific information to patients who are seeking to end a pregnancy. And yet we've heard from Indra and others that in terms of birth, it seems like no similar requirements, even of disclosures of like a managing maternal refusals comes up. And I just wondered what you thought of that particular tension.
So I think that they're connected, but also separate issues, right? The forced language that providers are made to engage in around abortion care is another attempt at stigma, power, and control, right? It's a tactic of terrorism to try to convince someone to make a decision that's in line with an ideology that may or may not be one that they espouse. The question around language and during the pregnancy, the delivery process, the postpartum period, I think boils down to informed consent, right? And those conversations, Mary Faith did this, we all signed these long legal consent forms that we sign away all of our rights to. I do it when I go to my doctor, when I go to my dentist. And the reality is that is not consent that is in any way, shape, or form informed, right? Because there are lots of things at play. There's an unequal power dynamic. There are things that are not discussed. There's the perception that regardless of what you do with this paper, that I can overrule it because I'm the one with the most power in the space. And then, I think as healthcare providers who are trained in this system, we also don't have a clear understanding of what this means, right? We're taught that this document will provide a protection from us from legal reprisal. Right. And so not that this is part of a process of making sure that the person that you're caring for actually knows what's happening and has the decisional capacity to make choices around their health and well-being. And so I think we're coming at it, and I like Indra's discussion of the impact of medical malpractice in the legal framework in medical care and how much that has absolutely shaped the way that we provide care, the way that we think about care, the way that we talk about care. Even for me, especially for me as an OBGYN, which is one of the most highly sued professions, all during my training, we're often taught, just get ready, you're going to get sued, right? Are you sure you want to do it? The litigation is heavy, right? We live in a litigious environment. And so the way that medicine and the law are so deeply intertwined, but not really discussed from the position of the person who's receiving care, is really phenomenal in the medical space, especially when we're talking about the reproductive health space.
Thank you. I'm going to take this moment after that very helpful, thoughtful answer to do my job as the CLE host and say it's now time for me to show you another secret word. And that secret word is delivery. I did see in the chat someone who said they had left briefly for the bathroom during the first posting of it. I can't repeat that word for you, but you might be able to figure out what the other word was. So it is delivery is the next one for your credits. So before I invite the co-hosts in to ask a few questions and then open it up for the full chat, I want to do a particular connection. And if I get it wrong, Dr. Perritt, you'll correct me. And this would be to ask Dr. Marshall, Mary Faith Marshall, could you, what I heard you say, Dr. Perritt, one of your sort of critiques was we have these policies out there, like ones that Dr. Marshall helped develop for ACOG, but they really don't give you information about what you're supposed to do, that there isn't a concrete ask in those many policies. And by the way, NAPW has a complete list of all the organizations, leading medical organizations that have addressed the issue of consent during pregnancy and also criminalization. So I wanted to give you a chance to respond to that.
You know, it's interesting. I was, thanks to Indra and thanks to Lynn, did some advising work for them on the Renat Dre case. And here's one of the things that I thought was, the whole thing was egregious, and I love the terrorism language, is that Renat Dre was never determined to lack capacity, never determined to have lacked decisional capacity. Under the law, you are, if you're an adult, you're presumed to be capable until you have been formally determined otherwise, right? Because that takes away one of our most important rights as citizens and patients, the right to consent to or refuse health care. When they didn't get the answer they wanted, they went to her husband, right? Who also said no, right? And then they just decided, well, we're going to do it. I've argued, and I don't know whether ACOG will ever go there, that at least the persons who, are members of that organization and who are fellows in that organization, who engage in coercive interventions in pregnancy, should be stripped of their fellowship, and that should be, a pretty public thing. I mean, one of the things that, those, all of us, on this call and attending it are either professionals or, soon to be professionals. The idea of a profession is that we have, a specific body of knowledge and expertise that we profess to use for the benefit of others. And thus, in theory at least, society gives us the right to police ourselves. Right? Part of that has long gone by the wayside because, many of us who ostensibly make those professions don't live up to them. But I think it's inherent on professional organizations to at least police their own in a public way and say, this is not okay. This is absolutely not okay, especially when you've got a document, a guidance document from your ethics committee that says not only is it not okay for individual clinicians to be, to coerce or attempt to coerce their patients, but it's not okay for institutions to attempt to use the law, right? So, which is what happened at, all over the place. Tallahassee Memorial. There was a second case at Tallahassee involving Laura Pemberton that had happened 10 years earlier, where they took her out of her home, right? So this was another VBAC scenario. She was giving birth at home or attempting to with a doula, went into the hospital to get some hydration because she was dehydrated. And they, she went back home, came in and took her out of her home. Right. So
One of the things that you mentioned, Dr. Marshall, that I think is really critical is this right of the dignity of refusal, the right of refusal. That's actually a thing. You can say no, right? You can say no to all of the things, and somebody who is enforcing their will on you in medical spaces, Savannah described it absolutely appropriately. That is assault, that is violence, that is abuse. It's an unequivocal response. And so it does behoove us to be able to have these conversations with students and trainees really early in their career. Your judgment cannot be used to enforce a decision on someone else. That too is coercion, that is abuse, and that is assault. And so the earlier and more frequently we can say that to those who will escalate to these points of powers where they can just say, yeah, you have decisional capacity, but I'm gonna do it anyway, right? We need to get folks early enough so we do make it very clear this is not the way that that practice occurs, right? Or should not be the way that practice occurs.
Informed consent means nothing without the right to refuse, right? They are two sides of the same coin. Right? So yes, I couldn't agree with you more, Dr. Perritt. Thank you.
And if you can, if I need to be corrected, you will. That people have asked in some of the questions, what's the difference between consent and informed consent? And informed consent requires the provision of information, not just about whatever you're specifically doing. And just, I want to make clear that in the context of the South Carolina case in Ferguson, it's not just consent to testing or even informed consent to medical testing. You must get consent to a search. So it isn't simply for medical purposes. It must be, if you're going to turn it over to state authorities, you also need a consent to a search. But
that was the cause of action, Lynn, at the Supreme Court, right? That was, once it got there, that was the cause of action, the Supreme Court just said.
That was the focus of it, absolutely. So I do want to turn to Savannah and Indra and ask, sort of related to this question of the responsibility of doctors, whether you could share both actually, any experience that you've seen, that you've worked on, both that describe some of the kinds of coercion that's used that may not have been discussed already, and also whether you've seen any intervention or any particular action that was respectful and that might have surprised you along the way.
Before you answer that, can I offer just one little tweak to that? Because I just want us to broaden the lens of actors here, because there are entire systems that people come into contact with. They're doctors, they're nurses, they're medical assistants, they're social workers, right? So there is an entire system. So in thinking about that, I would love to hear about the ways that we all collude within these systems to ensure that rights are non-existent for many folks. Sorry to tweak your question, Lynn.
We have the general counsels, the hospitals, or the medical council who need to be educated. Sorry.
Yeah, and I can't help but think, as we're in this conversation, and every time I'm in this conversation, we all kind of get our sector hats on, right? The legal sector, the medical sector, the birth workers, the grassroots, the organizers. But many of us have interfaced, right, with these systems, and our human experience, our visceral experience, our collective memory is ingrained in this conversation that we're having right now. And so I would be remiss if I just didn't acknowledge that of the 238 of us who are still here and in this conversation, the stories, the numbers of those most impacted are present in the room, right? And so while Indra and I can remark on cases and stories and instances and examples, I also just want to honor those listening and those still listening and your lived experience. And one of the things that keeps coming up for me is that often for people of color, because our bodily integrity is so disrupted so early in our lives, that for it to happen in a medical setting is not new or weird or different or alarming, not lessening how traumatic it is or impactful or the lifelong consequences, and even I would say intergenerational consequences, right, that live on in our cellular DNA and memory, but that it is highly normalized, right? And so it's interesting to orient to this work also as a doula and a birth worker, and to know that for so many of us, we would love to go in and be ushering in and bringing up the spirit of birth and rubbing backs and pouring essential oils and giving folks sips of water. But our center of gravity has become, especially if attending a hospital birth, to be a bodyguard, right? To ensure the safety and dignity and rights and consent of the birthing person. And so, of course, yes, I've seen hyperflexing of a pregnant person's legs. I've seen use of force. I've seen the pushing down on the fundus to exacerbate the progression of labor. I've seen the clock ticking at the 24-hour mark and the 36-hour mark, and the threat, right, of, well, do you want to harm your baby or do you want your baby to live, right? The choice that is a facade, a veneer of choice, but is really, as Dr. Jamila Parent called it, terrorism, right? And it's the stripping away of rights in praxis. And so I know that these complexities, the right of refusal, the informed consent, it's very complex for a survivor who's dissociating in a room, for a person who is bodily dismembered, who is apart from themselves, and who is having a hard time making a decision in a setting where there needs to be a paradigm shift around power. It's not just implicit bias training about, well, Black people feel pain too. It's actually a deeper human experience and understanding about who gets to be in control of their body and their circumstances and these major critical rites of passage, right? And so when you ask the question, have you seen it done right? Have you seen cultural respect? Of course, I've seen it with home birth midwives. I've seen it with traditional midwives. I've seen it in culturally affirming settings. I've seen it in spaces where there's respect and honor for religion and spirituality. And that's with all experiences across the reproductive life course, not just birth, right? And so I think there is this more vast understanding that we all need to have, not just about the event of birth, but across that lifespan and that continuum, where we actually can sit back and have hands off and allow the birthing person or the individual, wherever they are across their reproductive life course, to have their experience and be in full autonomy and control. And that does mean from start to finish, right? And so I think there's a deeper way in which we need to be brain trusting and think tanking about the culture of health, how it looks, not just in the birth event, but how it looks and what it is that we're doing. I think there's a savior complex. We haven't named that. And so the interventions are aggressive, the verbal interventions are aggressive, the physical interventions are aggressive, and the lack of choice becomes normalized. It becomes, I'm gonna go to the hospital and they're going to deliver me, right? And we have to have a complete and total paradigm shift. And I agree with Dr. Jamila Parent that that has to happen in the pedagogical setting. It does have to happen with medical students. It does have to happen there, but there's also a culture shift across communities that needs to happen. And so we're building that, we're doing that, we're trying to create it, and the advocacy is a part of it. And the legal aspect is a part of it, but it has to complement that broader societal cultural shift that we need and that we're calling for.
If I could just build on that, I was really struck by your use of the word disrupt and dismember and dysregulation and distant from ourselves. I have been very moved by a little anecdote I learned from a friend of mine, a colleague, Heather Thompson, who's a bench scientist, who informed me that mammals who have been separated from their parent at birth are not considered good research subjects. You can't use one of those mammals to test things on because they're considered too dysregulated. They're not, their mammalness has been altered by that disruption. And that's what we have currently, is we have disrupted mammals, and that disruption does transmit generation to generation. And this, thinking about that disruption, makes me think about one particular case to answer your question, Lynn, that I think contains all of this, both good and bad. And I think that's that's a good kind of example, because in the complex, nobody's free of it. So we're always right next to bad. We're, it's like our left arm is part of the bad and our right arm is part of the good. This particular example also happened at the Medical University of South Carolina. A pregnant person had, for, at least the last trimester of her pregnancy, been declining scheduling a cesarean surgery. She was diagnosed with a condition of her cervix that by many providers' accounts would make her a candidate for cesarean surgery, but she wasn't convinced. She wanted to go into labor. She wanted to reach that point in her pregnancy before agreeing to a surgery. And that was really hard for her providers. And she had multiple providers, which I think, in terms of like the system that you were talking about, Dr. Perritt, from reading her chart, it was clear. You can read the notes of some providers who have more trouble with this than other providers. And then you can see the importance of leadership when the head of the team makes a note in the chart that clarifies, this is our approach, and this is my example of a thing that went well. She wrote in the chart, we do not override the decisions of pregnant patients. They get to decide what happens to their body. She wrote it right in there, and she established a plan for how she was going to work with her team so that everybody could come along and continue providing care to this person, and how she was going to keep communicating with this person for the weeks that they had to go on this journey together. But then, because it's a complex, even though that leader doctor did that good work, by the time this woman, following the doctor's plans, admitted herself to the hospital, still declining the cesarean surgery, was then placed on emergency protective custody by the hospital. It remains unclear whose job it was to do that, but somebody put her in adult emergency protective capacity and put a guard outside her room until she consented to the cesarean surgery in this context. and delivered her healthy baby, who was immediately removed by the state because the baby was now placed in emergency protective custody. So the baby is not with parent for the first handful of days after birth. And then the state returns the baby to the care of her parent, but the parent has to have 24/7 supervision of her parenting for the next 3 months. Before then, the state decides to drop the case because there was no harm that could be found to begin with. So, there's so many entities and people who participated in that outcome. Certainly the hospital attorneys were consulted, social workers were consulted, social workers testified, in the hearing that happened a few days after the baby was removed. The various doctors, various specialties. And that's, both a lot of good happened in that case and a tremendous amount of bad, certainly more bad than good.
Thank you, Indra. This has been such an amazing conversation many of your comments and presentations answered some of the many wonderful questions, but I'm just wondering if our co-hosts who have been given the privilege of asking questions want to do sort of a lightning round. Each of you sort of ask a question and then our panelists could respond, or we can turn to some of the questions that have not yet been answered. Let me just encourage everyone to read those questions and the chats, because there's so much great information being provided. But please, maybe raise your hand and ask your question. Okay, Cindy Pearson, National Advocates for Pregnant Women.
National Women's Health Network.
Oh, sorry.
And I'll take your suggestion that we do a lightning round and just lift up this. The vision of the complex was so helpful that from no vantage point can we see everything. And from no vantage point can any one profession or any entity influence everything. So I represent the organized women's health movement and its connection to the birth justice movement. And for us, at least, its connection to the racial justice movement. And just lifting up the women's health movement has changed many, many things in the last 50 years. We haven't changed this. And I think it's because of the deep-seated patriarchy and racism. But we should keep trying, right? Organized consumer movement. So I just want to lift that up. It's not really a question, but throw it out for discussion in this lightning round of the co-hosts, co-sponsors.
And Farah.
So my question is this, and it really speaks to what Savannah and Indra were lifting up. When we're looking at these issues, very often we're focused and highlighting trauma, and in particular, Black trauma and that of Indigenous people and other people of color. And I want to create a little space to center joy and ask, what are some strategies that you're seeing in your work, especially Dr. Perritt and Savannah, that bring you joy and bring you hope?
Cindy, do you have a question?
Yeah, although that was a great question, Farah. Maybe that's the question people should end with. But I'm just thinking back about Indra's comment and Dr. Perritt's comments and the complex sort of system, that leads to reproductive oppression. I'm just thinking about the role of healthcare organizations, right? And thinking, even if you have doctors who are supportive of patients, you still have to operate in these healthcare systems. We're sort of seeing a conglomeration of healthcare systems, right? And some of them are religiously owned. So I'm just thinking about from the practitioners, advice for how doctors can stand up when they're in systems, right, that are pressuring them to do things that they don't want to do, and how lawyers might better support practitioners who are functioning in those kinds of environments.
I'm going to start. I don't know the answer to any of the questions, but I'm going to start anyway. I think, maybe with your question and comment, Cindy, because as a disruptor myself in many systems, in all the systems, I know that it also comes at a cost, right? And so we cannot pretend that disruption as an individual does not, that there are no consequences to it. And the decision that we all have to make is sort of, what price are we willing to pay what price are we able to pay? When we're talking about particularly folks who care for BIPOC communities, you're more likely to find providers of color providing care in communities of color. So the ask around disruption means that we're asking those of us who carry larger burdens in these systems to also disrupt and create consequences. Many of us are first generation, many of us are supporting communities and family members, right? So one of the things that I think is really critical that we begin to talk about really early in our discussions around collaboration, around disruption, around non-collusion and resistance is this question around power and who we're asking to bear the burden of this disruption and whether or not folks in greater positions of power can do more. Indra's comment about the head attending writing a comment in the chart is an important one that I don't want to be lost, because that direction from leadership makes room for other people who want to be able to reject, but are not able to take that risk for or against. Now, I always struggle a bit with this juxtaposition of like centering a provider in the conversation around risk, because when it's all said and done, I still am a physician. I still am often in a greater position of power and privilege than the folks that I'm caring for. And so my concerns about risk should never be pitted against, in my opinion, the concern around the risk for the individual and the disruption of their bodily autonomy. So I want to be very clear that this is not a conversation that should be an either or adversarial in any way, because my role is to be there to support them in the way that they need and is best, right? But I think that there are entire systems. Imagine how many folks had to collude for these outcomes to happen. Right? It isn't just one person. It is entire systems that really need to move toward disruption. And the more folks that are engaged in it, the less the individual risk is. And so that's my hope, that we can convince more people to band together, build power towards disruption of this work, in this work.
Can I jump in? And I just want to build on what you just said, Dr. Perritt. And that is this, it's a strategy. So one thing, hospital systems, the systems we're talking about, should be conceived of as moral communities. We are all responsible to one another. So, get rid of that hierarchical notion. At our place, we have not an ethics consult service, we have a moral distress consult service. So think about you being the clinician who is asked to do something that you know is wrong. That's the cause of moral distress. And these are concrete ways that you can change the culture in your institution by saying, hey, this is not okay. Here's the national guidance, here's the norm, and you don't get to do it. And we're going to hold our hospital administrators and executive leadership accountable to it or for it. And there's a great article by Annie Lyerly called Risk in the Pregnant Body. If you all have not read that, please do. It's awesome.
Does anybody else want to answer the other questions, including the very powerful one about joy?
I mean, I think I'm holding on to, and I often do hold on to Indra's description of the elephant circle, right? Because I think that there's a way in which birth has become an emergency event. It's become an urgent event. And in other settings and other cultures, even like drawing on various diasporas, that is not, right, the way that we look at birth, right? We look at it as a village commitment, a responsibility, right? A joyful crossing. And my heart breaks every time I hear a story, I read a case, I bear witness, I see what's happening inside of the systems, and I know that there's active work being done to resist, but we're not living inside of the culture of birth that we yet should be. And so I'm often inspired by images like what you described, Indra, and what your work is based and steeped on, and lessons that we can keep garnering and to draw not just joy from, but critical evidence from. And I think sometimes we think it's just a beautiful idea, but it's really evidence of how we can turn the tide on maternal mortality, how we can turn the tide on obstetric violence and bring justice about. And so there's so many ways in which I dream all the time with my eyes closed, with my eyes open, of what a culture of birth is supposed to be and what it can look like. And I'm trusting that in this space, we've hopefully moved people towards that and closer to that elephant circle. So I'm grateful for that gift that you all have given us. Thank you, Indra.
And
Can I add just to say that, like, I love so much about that, right? That there is the possibility of joy and transformation in this process. And that's the thing, right? And so many of the ways that we think about medical care is problematizing it. And birth is one subset of problematizing the entire body that showed up in medical spaces. And so I just wanted to name that too.
And I'm afraid we're going to end, and I'm not sure if we're going to just be cut off. So let me just say thank you to all of our amazing panelists, our co-sponsors, our co-hosts. We're sorry we did not get to all of the questions, and many of them, we will share them with all of the presenters who may or may not be able to send you an answer if they're particularly moved to. You can also write to them and to National Advocates for Pregnant Women at info@Advocates for Pregnant Women. And we do not mean to leave you without action. We are putting in the chat a petition regarding the Renat Trey case, as well as social media toolkit that you can use. We hope you will stay connected. We hope you will take part in the ongoing effort to bring this particular person, Ms. Dre, justice. And there's a poll you can fill out. Yes, you want to get this social media toolkit, and that you will continue to meet each other and carry on some of the very important conversations that appear in the chat, appear in the questions and answers. And just once again, thank you, everybody, and thank you for this particular circle of advocates and elephants.